5 seconds to go. Start. It was found that in such circumstances, the intervention of the government by promulgating the ordinance and later on substituted it by the impugned enactment could not be held to be violative of Article 14 of the Constitution. In the case of Dharamdutt and others versus Union of India and others, the court was considering the validity of Indian Council of World Affairs Act 2001. In the said case, again a similar argument was advanced before the division bench of this court. Rejecting the said argument, the court observed thus: Article 14 of the Constitution prohibits class legislation and not reasonable classification for the purpose of legislation. The requirements of the validity of legislation by reference to Article 14 of the Constitution are that the subject matter of legislation should be a well defined class founded on an intelligible differentia which distinguishes that subject matter from the others left out, and such differentia must have a rational relation with the object so to be achieved by the legislation. The laying down of intelligible differentia does not, however, mean that the legislative classification should be scientifically perfect or logically complete. We have already pointed out in an earlier part of this judgment that in the present case, successive parliamentary committees found substance in the complaints received that an institution of national importance was suffering from mismanagement and maladministration. The central government acted on such findings. Circumstances warranting an emergent action satisfied the President of India, resulting in his promulgating ordinances which earlier could not culminate in legislative enactments on account of fortuitous circumstances. At the end, Parliament exercised its legislative power under Article 245 of the Constitution, read with entries 62 and 63 of List 1. The legislation cannot be said to be arbitrary or unreasonable. It was further submitted that the provisions of the Societies Registration Act 1860 were effective enough which, if invoked, could have taken care of the alleged grievances. If there was any truth or substance therein, the same could have been found on inquiries being held. In our opinion, in a given set of facts and circumstances, merely because an alternative action under the Societies Registration Act 1860 could have served the purpose, a case cannot be and is not made out for finding fault with another legislation if the same be within the legislative competence of Parliament, which it is, as will be seen hereinafter. A similar submission was made and repelled in S.P. Mittal case 1983 1 SCC 51. The contention there was that provisions in the Societies Registration Act were available to meet the situation in Oroville and that the law and order situation could be controlled by resorting to provisions of the Code of Criminal Procedure. The Constitution Bench held SCC page 116 para 169 whether the remedies provided under the Societies Registration Act were sufficient to meet the exigencies of the situation is not for the court to decide, but it is for the government, and if the government thought that the conditions prevailing in the Oroville and the society can be ameliorated not by resorting to the provisions of the Societies Registration Act, but by a special enactment that is an area of the exercise of the discretion of the government and not of the court. The Constitution Bench also observed that assuming the facts brought to the notice of the legislature were wrong, it will not be open to the court to hold the act to be bad on that account. It was then submitted that the institution ICWA was singled out, and though there were several other institutions run by societies or other organizations which were in the grip of more serious mismanagement and maladministration, they were not even touched, and Parliament chose to legislate as to one institution only. This submission too holds no merit. Firstly, no other institution is named or particularized so as to be comparable with ICWA. Secondly, there can be a legislation in respect of a single institution, as is clear from the language itself of entries 62 and 63 of List 1. A single institution is capable of being treated as a class by itself for the purpose of legislation if there are special circumstances or reasons which are applicable to that institution, and such legislation would not incur the wrath of Article 14. In SP Mittal 1983 1 SCC 51, the impugned legislation brought with the object and purpose of taking away the management of Auroville from the Aurobindo Society and to bring it under the management of the central government under the provisions of the impugned act was held to be valid. The exercise of legislative power by Parliament was so to be justified as falling within the field of entry 63 of List 1. Their lordships referred to several decisions wherein the constitutional validity of similar legislations was upheld. A separate law enacted for one company were held not to offend Article 14 of the Constitution on the ground that there were special reasons for passing such legislation. It can thus clearly be seen that in the said case also the court took note of the successive parliamentary committees finding substance in the complaints received that an institution of national importance was suffering from mismanagement and maladministration. It was found that the central government acted on such findings. It was also found that the circumstances warranted an emergent action. Relying on the case of SP Mittal Supra, the court found that a single institution was capable of being treated as a class by itself for the purpose of legislation if there were special circumstances or reasons which were applicable to that institution, and in such circumstances the legislation would not incur the wrath of Article 14 of the Constitution. In the case of P. Venugopal versus Union of India, this court was considering the proviso to Section 11(1)(a) of the All India Institute of Medical Sciences Act 1956, void which the tenure of the petitioner therein was sought to be curtailed. Relying on the other judgments of this court, the court held the said proviso to Section 11(1)(a) unconstitutional and ultra vires. It was found that the facts of the said case were similar to that of D.S. Reddy Supra. It is thus a settled provision of law that though a legislation affecting a single entity or a single undertaking or a single person would be permissible in law, it must be on the basis of reasonable classification having nexus with the object to be achieved. There should be a reasonable differentia on the basis of which a person, entity, or undertaking is so to be singled out from the rest of the group. Further, if a legislation affecting a single person, entity, or undertaking is being enacted, there should be special circumstances requiring such an enactment. Such special circumstances should be gathered from the material taken into consideration by the competent legislature and shall include the parliamentary legislative debates. In the case of Chiranjit Lal Chaudhary Supra, This court found that the Sholapur mill was an undertaking of national importance, employing 13,000 people. It was found that till the managing agents took over, it was running in profits. Stop.